Today, we are going to talk about and focus on the 302 commitment procedure. In my experience, there are a lot of education, both at the master's and the doctoral level, that really spend a lot of time teaching risk assessment and safety plan. However, once folks get into the field and they're actually engaging in clinical work on a daily basis, sometimes then there's a lack of confidence whenever it comes to actually following through on the 302 procedure, and staff frequently need supervision or consultation due to feelings of fear and overwhelm and anxiety, especially about being able to execute this procedure correctly while also ensuring the safety of themselves and those who cannot protect themselves. And this is totally normal. That's why we have an entire lecture here on this. So, here we're going to dive deeper into the procedure, provide further clarification, and help ensure that you really have a very good understanding. As part of the Mental Health Procedure Code, the two-run process involves voluntary consent to receive psychiatric inpatient treatment. For individuals age 14 and older, they can independently consent to treatment. For those 14 and under 14, a parent or guardian must provide consent for voluntary mental health treatment. Voluntary hospitalization should always be presented as the least restrictive alternative. This means we continue to engage in conversations with individuals at risk, working towards a safety plan. That includes assessing their protective and their risk factors. We also evaluate their intent, their means, their plans, and their gestures, while encouraging them to utilize available resources to ensure their safety. Voluntary admission may be necessary if a person is unable to ensure their own safety or is presenting with suicidal or homicidal ideation, especially if these thoughts are associated with a plan, intent, means, and gestures. So, parents have the right to object to inpatient treatment if a juvenile has consented to it. This highlights the legal rights of parents and guardians, which must be carefully considered. It is essential for providers to understand the family dynamics they are working with, as often families are involved through court-ordered custody agreements, foster care, or other legal arrangements. Therefore, it's crucial to ensure that proper documentation is in place, including court orders that identify the child's legal guardian and the parent with the individual who has parental rights. This information helps us determine who our target population is and guides the appropriate steps we need to take. Once the necessary information is obtained, if the juvenile is voluntarily admitted, the parents or guardians must be notified by the hospital. This notification should include details about the admission and the proposed treatment plan. While parents or guardians have the right to object to inpatient treatment, they must do so through a court hearing, and that must be scheduled within 72 hours. During this hearing, they can formally object to the treatment plan, and it is important to note that a parent cannot simply remove a child from treatment, especially whenever it pertains to ensuring the child's safety. So, the 302 process involves an involuntary emergency examination. This treatment is up to 120 hours, which is 5 days. When an individual possesses a danger to themselves or others, or cannot care for themselves, to initiate a 302 procedure, there must be clear evidence that the person has an intent, plan, or means to harm themselves. For example, if an individual expresses intent to harm themselves and has access to weapons, or if they possess the means to carry out their plan, and safety planning becomes absolutely critical at this moment. This includes discussing medications in the home, how to secure potentially dangerous items, things like that. If an individual is unable to develop a safety plan and there's clear intent and means to follow through with harm, involuntary commitment must be considered. However, it's important to note that these behaviors or threats do not have to occur in the immediate moment, right here and now. They can be based on events or statements made within the past 30 days. So if a person has expressed a plan and an intent to follow through during that time frame of 30 days, they cannot commit to safety, then the 302 process should follow through with that. Ultimately, if the individual cannot contract for safety, action must be taken to ensure their protection. So the criteria for commitment requires Consideration of several various different factors. So, first, there must be evidence of a mental illness supported by documented psychiatric history and medical records that include a diagnosis. It's important to assess whether the individual has previously engaged in dangerous behaviors. Perhaps that's suicide attempts or attempts to harm others, and evaluate the nature of those behaviors. Additionally, the history of these behaviors should be reviewed, particularly within the past 30 days, to assess the likelihood of reoccurrence. The key question is whether the person's emotional health is unstable and if they are at continued risk to themselves or others without proper intervention. Imminent danger is the highest priority. If an individual is in imminent danger, we have to act to ensure their safety, even if they don't want to be protected. This is our responsibility to follow through with keeping people safe and addressing imminent danger. However, it's important to note that drug and alcohol abuse alone does not qualify as a criterion for commitment. Even if someone is struggling with addiction and mental illness, engaging in high risk behaviors, and facing immediate danger, the criteria for commitment cannot be solely based on substance abuse. While Act 53 addresses the involuntary commitment of minors due to drug and alcohol issues, there's no procedures for involuntary commitment based solely on drug and alcohol abuse for adults. So let's talk about how to file a 302 petition. This can be filed by anybody who is at least 18 years or older. In exceptional cases, a child ages 14 and over may file a petition. The petitioner must have firsthand knowledge of the individual's behaviors. This does not have to be a clinician. It could be a family member, a loved one, or even a concerned community member. The petitioner will be held responsible for providing testimony if a 302 hearing is followed through with. Act 77 affects the 302 process as an amendment to the Mental Health Procedure Act of 1976. This law mandates that all counties submit the names of individuals who have been involuntarily committed for inpatient psychiatric treatment to the state police. Under this act, anyone committed under sections 302, 304, or 303 is prohibited from possessing, using, manufacturing, controlling, or transferring firearms. Those seeking to file a 302 petition should be made aware of Act 77, as many family members have chosen not to pursue this option or to avoid their loved ones losing the ability to own or use firearms. The process for completing the 302 petition outlines as follows. An example petition is attached here in this module, so you can take a closer look. If you are the petitioner, you will need to complete pages 1, 2, and 3 of the 302 petition. These pages focus on the key factors we've previously discussed that must be met for 302 petition to proceed. Once the pages are filled out, contact the appropriate county delegate. Each county assigns a delegate who is responsible for reviewing the petition to ensure it's completed correctly and to determine whether sufficient grounds exist to authorize a 302. If there are sufficient grounds, the delegate will provide guidance on completing the warrant. So that's part 3 of page 5, and instruct staff to complete part 4, which is going to be page 6 of the petition, and the petition will then be considered complete. A copy of the petition must be retained for record. Depending upon the agency's policies and the procedures, the petition may be either kept as part of the client's record or tracked separately. Regardless of how it's stored, ensure that you follow the agent's safety procedures and maintain confidentiality. Once the petition is completed, you can contact 911 to inform that you have filed a 302 and that the individual needs to be transported to a local hospital. The original petition must be handed to the paramedics to give to the hospital. It's common practice to include copies of relevant medical records and with that petition so that first responders can have information about the individual's medications, diagnoses, recent mental health history, and past psychiatric hospitalizations. This information ensures the safety of the individual and helps the hospital staff provide the appropriate care. As we continue to examine the 302 process, it's important to note that once the warrant is signed by the delegate, it authorizes the individual to be taken to the emergency room for an examination. During that time, the individual should never be left alone. Sometimes this does happen whenever counselors are in moments of panic and they're trying to seek support, and they kind of, without being in the right mind, leave clients alone, and that's just leaving them at risk. So please ensure that you never leave the client alone. Communicate within the office to make sure that you can maintain safety for everyone involved. If you can't stay with the client, ensuring that you're handing them off to someone without ever leaving them alone if you need to step away and do something. Individuals presenting with suicidal ideation, intent, and a clear plan, again, should never, never, never be alone. Following the emergency room examination, the physician will determine if inpatient treatment is necessary. If inpatient treatment is indicated, the physician will complete Part 6 of the petition, which finalizes 302 process. The individual will be admitted for up to 120 hours, which is 5 days of an involuntary treatment. If the physician determines that there is sufficient grounds for an involuntary commitment, Part 6 will not be completed, and the individual will then be discharged. If the individual is unwilling to sign into voluntary treatment, if the delegate does not authorize a warrant for the petition, or if the emergency room physician rejects the petition, the information provided on the petition cannot be used for future 302s. In such cases, all new evidence will be required to initiate a separate 302 petition if needed again in the future. Once a 302 has been granted and the individual is hospitalized, the psychiatrist may offer the individual the option to voluntarily sign into a 201 to remain hospitalized voluntarily. Throughout this process, there may be several shifts requiring professionals to adapt based on the individual's need and the evolving circumstances, In the If the individual refuses to sign a 201A and continue inpatient treatment is necessary, a 303 hearing will be scheduled. A 303 hearing, with this, the goal is to extend voluntary treatment for up to an additional 20 days. To grant 303 commitment, the 302 commitment must be first validated. The petitioner for the 302 will be required to testify at a 303 hearing, providing justification for the initial 302. Once the 302 commitment is validated, the treating facility will also provide testimony, and the mental health review officer will determine whether continued voluntary treatment is warranted. Involuntary treatment is warranted. If the 302 petitioner fails to appear at the 303 hearing, the commitment may be dismissed. If the individual refuses to sign into a 201 and the hospital has no grounds for a new 302 position, the individual can be discharged within 2 hours. Outpatient court commitment process for a 304 involuntary mental health treatment extends beyond the 20-day 303 commitment and allows for up to an additional 90 days of involuntary treatment. Dangerous behavior does not need to be reestablished, as this has already been proven in the previous commitment. The 305 petition seeks to continued involuntary treatment for individuals already under 304. This particular commitment can last up to an additional 180 days of court-ordered treatment. A 305 commitment can be repeated every 6 months or for as long as the court deems treatment is necessary. Since dangerous behavior has already been established, it's not required to file a 305 petition. Outpatient court commitments can continue for an extended period, making it crucial for engage in an interdisciplinary teamwork to ensure, again, that this individual is being safe. That is our ultimate goal in this entire process, that they receive the appropriate care and they remain safe. The 302 commitment procedure involves many complex components, and it's understandable that you may feel overwhelmed, especially if individuals don't feel fully equipped to navigate this process effectively. I strongly encourage, just like everything that we're going to talk about in this course, ongoing training, supervision, supporting other professionals involved in risk assessment and safety planning and the 302 commitment procedures. It's going to be very essential to follow your agency's protocol while also adhering to the mental health procedure code. If you've got any questions regarding risk assessment, safety planning, suicide intervention, or the 302 commitment procedure, I hope that we can have these discussions in our course and in our discussion boards. I appreciate your time, and I hope that this information provides to be very valuable for you as you ensure safety of yourself and others.